I am summarizing the motion in limine for the Bryan Kohberger trial for the Idaho 4 murders. If you have not been following, I have gone through and summarized number motions 1 through 15, I believe. We are on number 16, so if you've not seen those videos, make sure you go watch them below because they will make way more sense and you'll follow along complete. So we have about 19 and I'm on number 16, so bear with me, but we're getting through it. So motion number 16 is about incomplete disclosures. Now they start talking about a Shane Cox and a Michael Douglas, that they gave supplemental disclosures, but with no opinions. And this is the defense talking about this. So Miss Massov, she's the little brunette co-counsel with Anne, and she is very feisty. Don't get in her way because she will come after you, but she has litigated in front of this judge before and is not afraid to say her opinion to him. And I will show you what I mean by that. So she goes on to address the Amazon records that were given to them. And she says that the Excel file, they got a huge Excel file with names and a bunch of metadata. And then they got another piece of evidence that was an Amazon click packet. And they believe both of them came from Shane Cox. He's the expert for the state. But there's zero context to it. So it's just a bunch of names and metadata. And for people who are laymen in that, they don't understand it. And this is what she's arguing to the judge. It has been happening time and time again, that they get this information, they get this data, they get this evidence in discovery, and nothing is coded, organized, easy to search, and there's no expert opinions attached to it. So you get all this information and you have no idea what the heck it means, what it's related to, and what their official opinion on it is as an expert. So what did the defense do? They got their own expert, Amazon expert, to look over the data, and they helped them make sense of it. And this is a Mr. Howell, so he's telling them what they're missing and what it means, and is helping them along in this process. Now, suppression, because warrants were extremely broad, and that's what they had asked for previously from the court, and it was denied previously. So here's the thing. I did some research. The judge came in and tried to, Massov talked about AI and she said machine learning, and he kind of snapped back at her and was like, well, isn't that just AI? Let me explain this because I've done some research and I've also done trainings for Microsoft and Google myself. Personally, I'm certified in both. Let me dumb it down this just a little bit so people can understand in like basic terms what this means. Machine learning is a subset of AI. Think of AI as the umbrella or a toolbox, and machine learning is just one tool in that box or one piece under the umbrella, right? So machine learning is just one specific approach within AI. So it just shows that the judge doesn't even know what he's talking about, but he has this crazy attitude like he does. Machine learning focuses on feeding the data to understand patterns of behavior. And it understands those patterns from the data that it collects, and therefore it improves itself over time without it being explicitly trained or programmed on one specific task. I hope that makes sense. So the judge essentially is misrepresenting the relationship, and he's oversimplifying this by calling it just AI. It's not AI. It's one part of AI. It's a type of AI. It's not just AI in general. So it begs the question, if he can get this wrong, what other things is he misunderstanding or not getting correct either? So Miss Massov got back up and said they limited the data for Bryan Kohberger and his purchases without the metadata and the context together. And the judge snapped back at her, and he's had attitude all day. He says, well, you got what they got, right? And she says, I put in my notes, why is he acting like this? Amazon clicks is how the state is going to present it. He tries to explain it, but how do I say this? So you can see my notes, it's crazy. So I'm trying to make sense of my thought process while they were talking, but she basically said, Massov said, no expert opinions before the motion in limine. So when they had to file their motion in limine, they didn't have the expert opinions about this data. And so it can be misleading in the way that the judge is explaining it. So he's talking about, oh, it's just a click. Well, that's the problem. He's oversimplifying the process that Amazon has and therefore it could be really misleading and confusing for a jury if the people explain it like that, like the state is planning on doing, and then giving no context. It's gonna make people think that he just clicked and put it in his cart and he bought it and that's it. So the judge went on to start arguing the case. He's been doing this all day. He was arguing like the case for the prosecution, and said it's bizarre, but he's not the expert. And he says Brian purchased a knife sheath and cleaning equipment and sharpener, and he was checking where it was at delivery after the murders. He looked at knives again. But Amazon is a shared account with his family, so how can you say he's the one that did this? The state got up and said their experts will not have opinions. They will testify to what the records say, and that's what the defense was concerned about, that they're going to enter opinions when they testify about this data and his purchases, and they don't want that. Not sure how that's expert's testimony. He hasn't heard it yet. Represented as a click, how something gets in your cart may be different when oversimplified. So the judge basically said that the state cannot put on experts with opinions, and that if they do, the defense has every right to combat that with their own experts' opinions and explanation. And so Massif and the judge were just ping-pong-balling it, going back and forth. And she said, yeah, okay, well, make sure that their myopic worldview is what they're held to, because there's a larger picture at play here. She got so heated with him. And the judge says state cannot go beyond what was put in report unless defense has an expert. They have to rebut it. Now, my last thought on this one, because this was a long motion, I'm going to end here, and then I'll pick up with my next video. But my question to you, or just in general, if Brian bought a knife, let's say he did, on Amazon, and he did not commit these murders, wouldn't he have the knife? Why doesn't he just give that up as evidence? Maybe he's going to at trial and say, hello, here's the knife I bought on Amazon, or that my family bought. It's obviously not the murder weapon because you can test it and there's nothing on it. So I personally would shut them up and be like, here, now leave me alone. I didn't do this. And the only reasons I can think that he wouldn't be able to do that is either he didn't purchase it and someone else in his family did and they don't have it anymore, or he did do this and therefore that's why he doesn't have it anymore, or doesn't want to produce it. So that was just my 2 cents at the end of this, thinking, well, if he has it, just give it up so that they have nothing on him with regards to those Amazon records and this sheath, especially if he can produce the knife with the sheath on it. Anyway, that is motion 16, and I will be back with 17, 18, and 19 shortly.